Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. What does one do if you believe the ex is physically or verbally abusive to your child? Now, let's paint this scenario a little more carefully. We have, let's say, a divorce. The parties had a child. There's been a custody order. Mom has custody of the child. Dad has parenting time with the child. And mom believes that the child is somehow being abused, physically or verbally or somehow. Well, there are remedies. You do have the ability to call your lawyer, have your lawyer file a motion to bring this to the court's attention. The court has remedies. The court can stop the parenting time. The court can insist that the parenting time be supervised. The court can insist on all sorts of things designed to address the issue. But what you really have to be careful with is whether or not you are having a situation of abuse as defined by the court. You see, I've had parents tell me that somebody's being verbally abusive to the child. And then later on, we learn that the nature of the abuse is some off-color language. Maybe somebody uses some expletive. What the hell's going on here? Or damn it, I thought I told you that. You know, those kind of things. There are levels of profanity. And maybe one parent is uncomfortable with profanity and has never utilized profanity, whereas the other parent just wasn't raised in that area with respect to that kind of thing and more frequently is profane. They probably were like that. I'm sure it didn't develop after the divorce. It's probably always been like that. So if that's the situation, it's not likely that the court's going to be overly impressed with that. That's one side of the spectrum. Another side of the spectrum is the child is being physically or sexually abused. Child's being beaten with a hanger or a belt or something like that. If that's what's going on, then clearly that's the other end of the spectrum, and motion should be filed to protect the child from that. Speaking about protection, though, I want to warn you about one thing. The moment you tell the court, I believe my child is being abused, that's the same moment the court says, oh, did you call Child Protective Services? They're going to ask if CPS has been involved. If you say yes, then they're going to see what the findings are of CPS and what the result was, and they're going to want to get into all of that. The court may even want CPS to be a part of future proceedings. If you say no, I feel my child has been abused, but I didn't bother to call Child Protective Services to even make a report, that's not going to look so great. Perhaps it's not such a great idea to label the behavior as abusive. It might be better just to tell the court, I'm filing this motion because I've been led to believe that my ex is beating my son with a belt. Let the court determine whether or not it's abusive or not. Or my child is being subjected to drug use. Or my child is being subjected to off-color remarks or profanity or something like that. Whatever the abuse is, if I were you, I wouldn't run to label it. I would just say what it is and let the court determine whether or not it's something that it wants to get involved in. The worst thing you can do after a divorce, after the court has spent months trying to work things out, is start coming back to the court on ticky-tacky things as defined by the court. It may be important to you, but ultimately, whether or not it's going to be important to court is a different question altogether. And who is the person qualified to make that assessment? I would suggest to you, more so than yourself, it's probably your lawyer. Your lawyer who practices in front of that court will probably know, you know what, Judge so-and-so is going to want to know about this. Or Judge so-and-so is going to think you're filing these things out of spite. He's going to look at this as an annoyance. He's not going to be happy. So your lawyer is uniquely qualified to make that assessment. Therefore, I think you should raise the issue with him or her and let them tell you what they think. If you have any questions about your case, reach out to us and we'll be glad to give you our sense of whether or not it's something the court would be impressed with and whether or not it would resonate with the court.